Muted.
Aaronsburg's Labor and Employment Practice Group. Today's session is the second of a three-part series that discusses up-to-the-minute developments in the fast-changing world that employers are living in as a result of the coronavirus crisis. FYI, the next and last session in this series is on June 4th at the same time, noon Eastern. I have the pleasure of being here today with the aforementioned Bob McTiernan and my fellow shareholders, Catherine Coop Irwin and Jeremy Farrell. On behalf of the 11 attorneys in our Labor Employment Practice Group and all of us at Tucker Aaronsburg, we thank you for joining us today as we share very timely legal information that employers should know as we start reopening the economy. Before we get started, I would like to acknowledge that these are extraordinary times, and we hope all of you and your families are safe and doing well. I also want to go over a few items regarding today's event. First of all, this is an audio-only conference. Second, you will have the opportunity to submit questions to today's presenters by sending your questions to Allison Hurley by email. Her email address is ahurley@tuckerlaw.com, ahurley@tuckerlaw.com, tuckerlaw.com. You may send in your questions to her at any time during the presentation. We will collect and address these, as many of them as possible, during the Q&A session at the end of the presentation. Today's audio conference is being recorded, and you will receive a follow-up email within 48 hours with a link to the recording. If you wish to follow up with any of the presenters, their contact information can be found on our firm's website, www.tuckerlaw.com, or feel free to reach out to any of us via Allison Hurley, again, ahurley@tuckerlaw.com. And lastly, it's important, I issued this disclaimer. This program is for general informational purposes. This content neither constitutes nor substitutes for legal advice that takes into account you or your organization's specific circumstances, legal jurisdictions, or regulatory concerns. Again, I welcome you to the presentation, and I would like now to introduce my colleague, Jeremy Farrell.
Hi, everyone, and thank you, Albert. I just want to echo those comments and thank all of you who are able to join us today for taking some time out of your afternoon to talk about what we think are really important issues facing employers during the ongoing COVID-19 pandemic. Our first segment today is going to be split between me and my colleague, Kate Coop Irwin, and we're going to talk about the paid leave provisions in the Families First Coronavirus Response Act, or the FFCRA. To give you all a roadmap of how that presentation is going to be structured, I'm going to spend the first 10 minutes or so giving you all a high-level checklist of things to think about when your employees call you up on the phone or send you an email and ask for FFCRA leave. And what I think we've collectively found as a practice group here at Tucker is over the past 6 or 7 weeks of living with this law, employers really don't have their feet under them just yet with respect to how to administer it. And I think that's really understandable given the circumstances under which the law was passed. But because the FFCRA does remain in effect until the ball drops on New Year's Eve and is now a law that's being actively enforced by a federal agency, we thought now was a pretty opportune time to get back to basics so that we are all adequately prepared to handle the FFCRA through whatever it is the next phase of this pandemic will hold. After my 10 minutes or so, Kate is going to do a deeper dive into some of the more nuanced issues that have tripped up employers in administering the FFCRA, and we are going to close out by alternating through some potential real-life examples of how to administer the FFCRA in situations that some of you may be encountering in the coming weeks as we all work through this quote-unquote new normal. So the FFCRA, remember, is a law that applies to all private companies who have fewer than 500 employees. And it's a law that actually creates two separate paid leave entitlements. The first one is what we call emergency paid sick leave, or Kate and I will refer to it as EPSL. It's a short-term leave. It exists up to a max of 80 hours, and it's available to your employees for 6 very specific reasons that have been set forth in the law. This emergency paid sick leave, subject to a few minor exceptions, is available to all of your employees regardless of their tenure. The second type of leave that is created by the FFCRA is what we call the expanded FMLA leave, or EFMLA, as Kate and I will use for shorthand throughout our piece of the presentation. This is a much longer term leave. It lasts throughout the traditional 12-week time span that normal FMLA leave lasts. It's available for only one of the 6 reasons that the emergency paid sick leave is available for, which I'll talk about in just a minute. And it is available, subject to a few exceptions, to all of your employees who have worked for you for longer than 30 days. So when a request for FFCRA leave comes through your door, the very first thing you want to do is confirm that the leave request is actually for a covered reason, because not everything that has some connection to COVID-19 is actually going to prompt FFCRA leave. So let's talk first about the short-term paid leave program created by the FFCRA, which is the emergency paid sick leave. That leave is only available to employees who cannot work or who cannot telework, meaning that you actually have work for them to perform that they cannot do for one of these 6 reasons, which I'm just going to paraphrase. The first reason is that the employee is subject to a government quarantine or isolation order, and Kate's going to explain in a little bit more detail what that means. The second reason is that the employee is told by a doctor or some other sort of healthcare professional to self-quarantine because of COVID-19 concerns. The third reason is that the employee, him or herself, actually has COVID symptoms and is actively seeking a diagnosis of his or her illness. The fourth is that the employee is caring for someone with whom they have a close relationship who's been ordered to quarantine themselves either by a government or by a doctor or other healthcare professional. The fifth reason is that the employee is caring for his or her son or daughter whose place of care, schools, daycares, have been physically closed as a result of COVID-19. And the sixth reason, and nobody really knows what this one means yet, is that the employee is experiencing symptoms specified by the Department of Health and Human Services. Since HHS has not specified any such symptoms yet, we don't need to worry about it just yet. So those are the 6 reasons for which the up to 80 hours of emergency paid sick leave is available. The emergency FMLA leave, the much longer 12-week leave, is available only for the 5th reason that I just mentioned, the employees who need to be absent to care for their son or daughter whose school or daycare or other place of care has closed. That's the only reason why one of your employees would be able to take the much longer EFMLA leave. And so the reason why your employee is saying that they cannot work is not one of those reasons that I've just mentioned. You are not in a world where the FFCRA applies. And so you'll need to think about whether or not the employee's leave qualifies under other laws like the regular FMLA or a state local leave law or under your PTO policy. So after you've confirmed that the employee has requested leave for an appropriate reason, step 2 will be to make sure that you get the information and documentation that you need to get from the employee to make sure that, 1, they're actually leave is for an appropriate purpose, and then 2, to be able to seek the tax credits that the federal government is going to use to pay you back for this paid leave. And Kate's going to talk a little bit in more detail about how to do that and the documentation that you'll need to require. Once you get that documentation, you need to work with your employee as part of step 3 to figure out the logistics of how this leave is going to be taken. One of the things to think about is whether or not the leave is going to be taken in one big block of time or in smaller intermittent chunks. This is what we call intermittent leave, and it is available under certain circumstances under the FCCRA, something that Kate is going to teach you about here in just a couple of minutes. The other thing that you'll want to bear in mind is that when you have an employee who's requesting leave, and that employee is actually eligible for leave under multiple different laws, for example, both the emergency paid sick leave and the emergency or the expanded FMLA provisions, or, for example, some PTO under your existing policies, you need to think about how all of those leaves are going to work together, the order in which those leaves are going to be run, whether any of them can be run simultaneously. The FFCRA has very specific rules on all of those things that you need to make sure that you think through, and we're going to tease some of those out in the examples that Kate and I are going to work through a little bit later in this presentation. So once you have a handle on how the leave is going to look, step 4 is to figure out how many hours of paid leave the employee is actually entitled to receive. And that is something that changes depending on the type of FFCRA leave that your employee is asking for. So let's start with the EPSL, the short-term emergency paid sick leave. This is split up between full-time and part-time employees. Full-time employees are those employees who normally work more than 40 hours in a work week. So for all full-time employees, regardless of whether they work 41 hours every week or 50 hours every week or 60 hours every week, they are eligible for 80 hours of emergency paid sick leave. And by contrast, part-time employees, those employees who normally work something less than 40 hours in every work week, are entitled to emergency paid sick leave for the number of hours that they normally work over a 2-week span. So if you've got an employee who is normally scheduled to work 25 hours a week, he or she gets 50 hours of emergency paid sick leave. The EFMLA works a little bit different because remember, it's a much longer leave program. It's available for up to 12 weeks. And what the EFMLA does is it basically draws a line between the first 2 weeks of leave and then the last 10 weeks of that EFMLA leave. Typically, the first 2 weeks of EFMLA leave are going to be unpaid, like the normal and regular FMLA would be. That is, unless the employee chooses that they want to run either their accrued PTO or their emergency paid sick leave, which you'll remember exists for both childcare as well as the EFMLA provisions. The employee can choose to run those two paid leave programs during the first 2 weeks of what would otherwise be unpaid EFMLA leave to ensure that they don't have a gap in time where they're not receiving any pay while they're out on leave. And then during the last 10 weeks of the EFMLA leave, the employee is entitled to be paid for the number of hours that they normally would have been scheduled to work during a time period that they actually take leave. And so the next step, step 5 after that, is to figure out how much money you actually need to pay the employee for the number of hours that they're going to be out. And again, that depends on the type of FFCRA leave that the employee is requesting. But the very first step, sort of regardless of the type of leave, is you need to figure out what the employee's quote unquote regular rate is going to be. A regular rate is something, a concept we're all probably familiar with. It applies when we're trying to figure out how much overtime we need to pay somebody. But what's important for everybody to remember is that when you calculate an employee's regular rate under the FFCRA, you have to follow a different formula than you do when you're just trying to figure out overtime. And that's because under the FFCRA, the employee's regular rate is actually a 6-month weighted average. So you actually have to do a 6-month look back in order to figure out what the employee's regular rate is going to be. You can't just simply go with the employee's base hourly rate. And then once you figure out what the employee's regular rate is going to be, you need to figure out how much of that regular rate you need to pay to the employee depending on the type of leave that he or she is taking. So if you go back to the qualifying reasons that I mentioned a little bit earlier in this presentation, employees who are absent from work because they're subject to a quarantine or isolation order either from a government or from a doctor, or employees who have COVID-19 symptoms and are actively seeking a diagnosis, while they are on FFCRA leave, you have to pay them their full regular rate, assuming that's above the minimum wage, calculated as I've just explained, up to $511 per day. That's the cap that the FFCRA places on this type of leave. For all other FFCRA leave reasons, whether they exist under the EPSL or the EFMLA, you pay the employee only 2/3 of their regular rate, and pay for those days of leave is capped at $200 per day. So there's different caps and different payment formulas depending on the type of leave that the employee takes, and you want to make sure that you bear those in mind as you calculate how much paid leave your employee receives. And then finally, the last step is just to make sure that you're tending to your post-leave obligations. Remember that these are job-protected leaves, so you're going to need to restore your employees, absent some exceptional circumstances, to the same or a very nearly equivalent job as to when they left. There are anti-discrimination and retaliation provisions in this law, so people who take FFCRA leave are in their own protected class. And then finally, remember to seek your payroll tax credits. The IRS has given you guidance on how to do that, and I know Kate's going to talk about that a little bit in her presentation. And so with that, I'm going to turn it over to Kate.
Thanks, Jeremy, for that very informative summary of the FFCRA. Now, I would like to take the next section of our presentation to answer some common questions that many employers have asked us over the past few weeks and months when dealing with the FFCRA, including how do you calculate the number of employees for purposes of the FFCRA 500 employee threshold? Are certain employers and employees exempted from the FFCRA? What information or documents can you ask that an employee requesting leave provide to you? And what do you have to maintain if you're going to take that IRS tax credit? What are some issues with intermittent leave? And what is the scope of some quarantine and isolation orders? So let's dive in. First, how do you as an employer determine if you have 500 or less employees for purposes, fewer than 500 employees for purposes of the FFCRA? Now, employers are covered by the FFCRA if they have fewer than 500 employees, and this is key, at the time the employee takes the leave. So if you have had some fluctuation in your employment roles and employment numbers over the past few weeks and months, like many of us have, if you've had to make off layoffs and then conducted rehires, you need to recalculate that 500 employee threshold if you're around that time period. Now, when calculating a 500 employee threshold, you should include all full-time and part-time employees working within the United States and its territories. You must also include employees on leave, temporary employees who are jointly employed, and day laborers supplied by a temporary agency. Workers who are independent contractors under the FLSA standards are not considered employees for the purposes of the 500 employee threshold. Now, what if you're a company that may have some joint ownership with another company or as a wholly owned subsidiary? For those purposes, are commonly owned companies considered a separate employer, or are they treated as one for purposes of calculating the 500 employee threshold? Generally, separate companies will be treated as separate employers under the FFCRA unless they meet what is called the single employer test, which considers factors such as the common management, interrelation of operations, centralized control of labor relations, and degrees of common ownership and financial control. Now, this is a very fact-specific test, and any employer attempting to claim single employer status to avoid being designated as a covered employer under the FFCRA should consult with legal counsel. Now, how about even if you're an employer with less than 500 employees, are there any employers that are exempt from the FFCRA? Well, businesses with fewer than 500 employees, 50 employees, whose viability would be jeopardized if it had to provide paid leave under the FFCRA may be exempted. Those are what we call small employers, businesses with fewer than 50 employees. And again, the standard is viability, undue burden that would be jeopardized if it had to provide paid leave under the FFCRA. Now, this is, again, a fact-specific inquiry. It shouldn't be made broadly across the scope. It should be made and evaluated upon each request for leave, evaluating the employee's status within the organization, the financial burdens on the organization in that moment in time. And we also suggest consulting with legal counsel if you're going to claim exempt status under the FFCRA for small employers. Are certain employees excluded from the FFCRA? The FFCRA permits an employer to exclude an employee who is a healthcare provider, and that's a specific definition under the FFCRA's regulations, or an emergency responder. How about the question of whether or not recently laid off or furloughed employees are entitled to paid leave under the FFCRA? So what if they were recently laid off and they've now come back and requested leave? The answer is no. The FFCRA applies only to current working employees. It doesn't cover former employees who were laid off or furloughed during the current pandemic. Can you as an employer lay off or terminate an employee who's on FFCRA leave? So if you have an employee who's requested 12 weeks of childcare leave and you have to make some reductions in force, is that employee cloaked in protection because they're currently on leave? And the answer is no. Like FMLA leave, an employer can lay off or terminate an employee on EPSL or EFMLA for legitimate business reasons that are unrelated to the employee's use of that leave. So you certainly, if you're talking about hours worked, you couldn't take into account the fact that that employee had been off on leave and had not recently worked any hours. You can make those decisions based on legitimate business reasons, and you should, of course, document those legitimate business reasons because they could be subject to challenge. If an employer terminates an employee who is on leave under the FFCRA, the employee will also not continue to receive those EPSL or EFML benefits after the layoff or termination. Now, what information can an employer require that an employee provide to it in support of the request for leave? Covered employers can require that employees taking either EPSL or EFML provide the following information. First, the employee's name. Second, the stated qualifying reason for leave. Third, a statement that the employee is unable to work or telework for the stated qualifying reason and the requested leave date. In addition, depending on the qualifying reason, an employee taking EPSL must also provide the employer with, if it's for the employee's own illness related to COVID-19 or treatment, the name of the government entity that issued the COVID-19 related quarantine or isolation order that applies to the employee, the name of the government entity, or the name of the healthcare provider who advised the employee to self-quarantine due to COVID-related concerns. If the request for leave is related to caring for an individual who might be affected by COVID-19, self-isolating, etc., you can request the name of the government entity that issued the quarantine or isolation order for the person being cared for, and the name of the person who is being cared for and the relationship to the employee. Same for a healthcare provider who has advised the individual being cared for to self-quarantine. You can ask the name of that healthcare provider, the name of the person who's being cared for, and the relationship to the employee. Now, if the request is for EFML, to care for a child whose school or child care facility has closed, you can require that the employee provide the name of the son or daughter being cared for, the son or daughter's age, the name of the son or daughter's school, place of care, or child care provider that's closed or unavailable to coronavirus-related reasons, and a statement that the employee has to care for the child and that nobody else is available to care for the child. Now, we at Tucker Arensberg have drafted forms that ask all of these questions and are happy to provide them to you. So if you'd like copies of these forms, feel free to reach out to me or any of us on the call and we can provide them to you. Now, for tax purposes, it's important to note that the information that I just went over is the same information that the IRS requires that an employer maintain if taking those tax credits to be reimbursed for payments made under the FFCRA. And the IRS actually requires that you maintain that information in these records for 4 years when taking the tax credit. That's 4 years. Now, let's talk briefly about intermittent leave. Must you provide or permit an employee to take intermittent leave under the FFCRA? The answer is no. An employer may, but is not required to provide an employee with intermittent leave. If you agree to provide an employee with intermittent leave, we suggest that you consider having and establishing that agreement in writing, but it's not necessary. And you can decide, for example, the smallest increment of leave that works for you as a company. Now, there's been much confusion and questions regarding what is an actual isolation order or shelter in place or quarantine order. When the FFCRA first rolled out, we weren't sure if it meant an actual piece of paper directed to that individual employee from a government entity or a healthcare provider that said, you must self-isolate or quarantine. And so the Department of Labor's rules indicated that these quarantine or isolation orders are in fact more broad than what we had originally anticipated. And they state that quarantine and isolation orders include when a federal, state, or local government order, or local government orders or advises categories of citizens including citizens in certain age ranges or with certain medical conditions, to shelter in place, to stay at home, to isolate, quarantine, etc. So this means that broad government orders, including, for example, guidance from the CDC on its website, recommending that persons with pre-existing conditions self-isolate, can be relied upon by an employee when requesting EPSL. So with all of that information, now let's put this legal guidance that we've talked about and Jeremy's talked about into some context by going over some real life examples. So a situation that employers may face in the coming months is related to employees who are starting to schedule or reschedule non-emergent surgeries that were postponed or delayed due to the pandemic. To take this fact scenario, an employee comes to you and indicates that he is going to undergo a routine surgery that had been postponed during the pandemic and that will require him to be out of work for a few weeks to recover post-surgery. The employee also adds that the hospital and his physician are requiring him to undergo a COVID-19 test at the hospital prior to the surgery, and that he needs to report during business hours to take the test, and that he needs to self-isolate for 3 days after taking the test and prior to surgery. Is any part of this time off covered under the FFCRA? Well, consistent with Jeremy's advice, first let's determine, is the reason covered under EPSL or EFML? Well, it's certainly not related to childcare, but what about the other reasons? Well, under the FFCRA, reason number 2 and 3, an employee qualifies for paid sick time if the employee is unable to work or telework due to a need for leave because the employee, 1, has been advised by a healthcare provider to self-quarantine related to COVID-19 or is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. So the days the employee is ordered by his physician to self-quarantine related to COVID-19, those 3 days before the surgery, would qualify as an EPSL reason. Now, the time spent at the hospital undergoing the test would likely not be covered because the employee is not experiencing symptoms. So the requirements under the law state is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. So you're missing that first part. So the time spent self-quarantining after the test would be covered, the time taking the test, perhaps not, unless there's some additional circumstances. Now, it's important to remember, however, that if the employee can telework during the time that they're ordered to self-quarantine, they would not be eligible for leave. So if the employer's business requires the employee to be on site, they would qualify for leave. If the employee can telework from home, they would not qualify for leave. Finally, you have to determine, is the employee eligible? In this case, under EPSL, there's no minimum requirement for a time for pre-employment before the need for leave. The employee was employed at the time. Make sure, of course, that the employee has not already exhausted the leave. So that in this case, if the employee had not taken EPSL previously, they would be entitled to it. Now, can you require the employee to use PTO days for the time missed pre-surgery while undergoing the test or quarantine? No, if the employee wishes to use those days, the employee can do so at his election. And then finally, don't forget about regular FMLA. What about the time the employee is absent from work post-surgery? What leave applies to that time, and is it paid? Well, if you're an employer who is not covered by regular FMLA, even though you might be covered by EPSL, the employee would not be entitled to have this time covered off under FMLA. You would still apply your normal PTO and other policies. If you are a covered employer under FMLA leave, the same standards for FMLA leave would apply. Evaluate whether or not the employee, in this case, had been employed for 12 months and had worked the requisite number of hours, even though they would have been covered under EPSL and no employment thresholds apply for the rest of the time post-surgery. And then, of course, don't forget about the Pittsburgh Paid Sick Days Act and other policies. So I'm going to turn it over to Jeremy for our second example, and then I'll go over our third example. Jeremy?
Yeah, thanks, Kate. All right, everybody. So for my example, I'd like you all to picture that you are the HR director at a retail store that's just reopened as part of Governor Wolf's yellow phase here that we're now experiencing here in Allegheny County. So your employees are recalled to work. One of them has 2 young kids who are in elementary school, who's right now, the school is closed, the kids are home doing virtual learning. Your employee tells you that there's nobody else that's able to take care of the kids and reminds you that he has 3 weeks of PTO in the bank. And so he asks you, the HR director, to take paid leave. And so how do you work through that request? First question, as we talked about earlier, is you need to figure out whether or not the employee is eligible for FFCRA leave or any other leave of the various types that Kate just described. So here, because we have an employee who is asking for leave to care for a child because of a school physical closure, that's the one reason that doubles up and qualifies for leave under both the EPSL and EFMLA provisions of the FFCRA. So he's eligible for both of those, and he's got 3 weeks of PTO in the bank, and it's likely that that policy would apply to this leave as well. So here you've got 3 different types of leaves that you need to be working through administering with this particular employee. My next question, though, is what happens when the children's school closes for summer vacation in the next couple of weeks? Is the employee still entitled to the leave that we've just described? And the answer is no. If you go back to the beginning of our discussion, EFMLA and EPSL is only available when the school is closed because of COVID-19 reasons. But when June rolls around and schools are closed for the ordinary summer vacation, that has nothing to do with COVID-19. And so in a lot of examples, my headphones dropped out for a second there. So in a lot of examples where people, school closes for the summer, the qualifying need for FFCRA goes away. The exception to that, though, that the DOL has just indicated is that where the children do have a summer program, some sort of a summer care provider, and that summer care, whether it be a camp or something like that, is also itself closed because of COVID-19 reasons, it's possible to extend FFCRA leave to cover that as well. So then you move on to thinking through how you need to sequence all of these 3 different leaves that the employee is entitled to. And remember, because we're dealing with the child care leave here, we're in the EFMLA world where we're dealing with potentially 12 weeks of leave that is available to this employee. And as you remember, I mentioned that there was sort of a line drawn between the first 2 weeks of EFMLA leave, which is ordinarily unpaid, and then the last 10 weeks, which is paid pursuant to the 2/3 regular rate formula that I talked about earlier. Let's just say that our employee here does not want to lose any pay during those first 2 weeks, and he decides that he wants to use the emergency paid sick leave, the EPSL, that is available to him to cover his absences during the first 2 weeks, because he knows that that leave is eventually going to go away at the end of the year anyway. But let's say that you, as the HR director, want the employee to use his PTO instead, because that is something that can continue to be rolled over year after year after year under your policies. Is that something that you, as the HR director and the employer, is that something you're allowed to require your employee to do? And the answer is no. So during those first 2 weeks, which are the ordinarily unpaid weeks of the EFMLA, the employee gets to pick what they want to use. So if the employee decides that he wants to use his emergency paid sick leave under the FFCRA without dipping into his PTO, that is his prerogative, and you as the employer cannot require him to do otherwise. The answer changes, though, a little bit in the last 10 weeks. So let's say we're living in the example where this employee's children do typically go to summer camp, and that summer camp is closed, and so the employee wants to extend his FFCRA leave into several weeks throughout the summer. Can you now tell the employee that he has to run his PTO concurrently with the remaining weeks of EFMLA leave that are available to him? And the answer is yes. And yes, assuming that your PTO policy would ordinarily cover child care leave like we're talking about here, either the employer or the employee has the right to say whether or not the PTO will run concurrently with the remaining 10 weeks of EFMLA leave. So how this would work here, you would take the 3 weeks of the employee's PTO, you would run that simultaneously with the beginning weeks of EFMLA leave, and while the PTO is still in effect, you would pay the employee pursuant to your PTO policy until that leave is exhausted. And then you would pay the employee pursuant to the 2/3 regular rate formula for whatever weeks he has remaining of EFMLA leave. So I hope that makes sense. That concludes my first example, and so I'll turn it back over to Kate. But if you have any questions, please feel free to email them in.
Great. So our third example deals with the situation that many employers are facing when bringing back previously laid off or furloughed employees. So in this fact scenario, an employee who was rehired less than 2 weeks prior comes to you and says that she needs leave to care for her minor children, whose summer camp style daycare has been canceled. She would like to take intermittent leave for 4 hours a day, 3 days a week, as long as possible to care for her children. Now, prior to her layoff or furlough during the pandemic, in November of 2019, she also took 8 weeks of FMLA leave to care for her seriously ill mother. So is this employee eligible for any type of leave under the FFCRA? So again, applying the steps that we've talked about. The first question, is this a covered reason? So she's requesting to take leave to care for her children, her minor children, who she has indicated their summer camp style daycare has been canceled. So as Jeremy just discussed, the Department of Labor has ruled out new guidance indicating that even though school's out, the summer daycare programs, cancellations would be covered under the FFCRA. So the second step, is the employee eligible? Now remember, this is childcare EFML, and that requires an employee to be employed for 30 days. And in this example, the employee just returned and has only been on the payroll again for 2 weeks. So at first blush, it appears that she would be ineligible. But the regulations issued by the Department of Labor sought to address this situation and state that if an employee was laid off or otherwise terminated by the employer on or after March 1st and was rehired, and the employee had been on the employee's payroll for for 30 or more of the 60 calendar days prior to their layoff date, they would be covered. So if this employee was laid off on February 28th, 2020, she would not be eligible for this type of leave. However, if she was laid off on March 1 and she'd been on the payroll for 30 days of the last 60, meaning from January 1 to March 1, she would be eligible. Now, moving on to the intermittent leave piece. As discussed above, you're not required to grant a request for intermittent leave. So in this case, however, if the employer wanted to grant the request, it could do so, or it could grant a version of the request. For example, if it's inconvenient for the employer to have the employee there for a half day, say they have to bring in an employee to cover a shift, or there are minimum staffing requirements, and it wouldn't make sense for the employee to come in for simply 4 hours a day. Unlike regular FMLA leave, where you would have to grant that request, you could say, I'm willing to grant you intermittent leave in the form of you taking 3 full days off a week. However, I can't grant your request for you to take only half days during that time. And again, we would recommend that you consider establishing that agreement in writing. And then the third step, of course, how much leave is available to the employee. Under this example, the employee already used 8 weeks of FMLA leave, applying the employer's normal process for calculating leave. Let's say in this example, the employer uses the rolling back method. The employee used 8 weeks of FMLA leave, has 4 weeks left to be applied toward any intermittent leave. In this example, 3 days per week for the remainder of 2020. Again, it's really important to document both the request and the agreement reached regarding intermittent leave, and consider evaluating similar requests for intermittent leave consistently, according to the same standards, to avoid any claims of either discrimination or retaliation by granting only certain employees intermittent leave and not others. So I'll turn it over to Jeremy for our final and fourth example, and it was lovely to speak with you all this afternoon.
Okay, so we're going to close everything out, at least our piece, by being the HR director for the same retail shop that we were in my last example. This time we have an employee who doesn't have kids and is able to return to work. This is a full-time employee, and after a couple of weeks, the employee comes down with flu-like symptoms, fever, dry cough, shortness of breath. They call you in the morning to tell you they have these symptoms and that they're going to be taking off work to get tested for COVID-19. The employee is tested later that day and then has to wait 3 days to receive the results of the test. The first question is, what, if any, of that time is covered by the FFCRA? So if you go back to the list of qualifying reasons that we talked about earlier in our talk today, reason number 3 was that the employee has symptoms of COVID-19 and is actively seeking a medical diagnosis. And so our employee falls into that bucket, and so therefore is entitled to the short-term emergency paid leave. Because he is a full-time employee, meaning that he works more than 40 hours, he's eligible for up to 80 hours of emergency paid sick leave. So of the time that I just mentioned, what portions of it are actually compensable under the FFCRA? So the general rule is that the time the employee spends taking affirmative steps to get a diagnosis, making an appointment, waiting for the appointment, going to the appointment, all of that is going to be covered. So certainly the time associated with testing is covered. But what about the time that the employee spends waiting for the test results? And as Kate alluded to a couple of minutes ago, that can depend on a couple of things. One being whether the employee is able to telework or not, whether you let them do their job remotely or whether it's something that needs to be done in the shop or in the office. If the employee does not telework and you do not allow that employee to telework, then the waiting time, waiting for the test results, is going to be compensable under the FFCRA. However, even if this particular employee was able to telework because he or she is sick and actively experiencing the symptoms that are potentially related to COVID-19, that waiting time would still be compensable. As Kate suggested earlier, it might be a different example or a different answer if that employee was able to telework and was not sick and was instead maybe getting testing because they're afraid that they came into contact with somebody who had COVID-19 symptoms. So what if the test then comes back positive? We now have a different reason for EPSL that we need to think about. Remember that if an employee tests positive, the doctor is likely going to tell him to self-isolate for a period of time to ensure that there's no infection of others. And the second reason for emergency paid sick leave is that the employee has been advised by a healthcare professional to self-quarantine or self-isolate because of COVID-19. So if the test comes back positive, we still have a qualifying reason for EPSL, albeit a slightly different one than the one that we started with. And what's important to remember here is that this is a full-time employee, so he gets 80 hours of EPSL. That is 80 hours total. It is not 80 hours depending on for each of the 6 different types of EPSL leave. So if you were to follow our example, and let's say this employee normally worked 8 hours a day and was out for 4 days waiting for the test results and going to get the test, and that employee has already used up, in that example, 32 hours of EPSL and has only 48 hours remaining. He doesn't get a new 80 hours for a new EPSL reason. It's a one-time leave bank. But what if, on the other hand, the test were to come back negative? The employee doesn't have COVID-19, but he or she is still sick and doesn't want to come into work. What do you do? Here you've got an employee who is ill with a non-COVID-19 related illness, and so you're outside the world of the FFCRA. So you're going to have to think about laws or policies that might apply to the employee in that scenario, which could be any number of things. It could be your PTO policy, your sick leave policy. If you are covered by the FMLA, you'll need to think about that. If you do work here in the city of Pittsburgh, you now have the Pittsburgh Paid Sick Days Act to think about, or potentially the Americans with Disabilities Act, which I know is something that Albert is going to spend some time talking about today. So with that, I will thank you all and turn it over to Albert.
Thanks, Jeremy. Thanks, Kate. Also, we have 3 more topics to cover with you in our remaining time. I will, as Jeremy mentioned, discuss how to handle accommodation requests, requests that may be covered by the Americans with Disabilities Act. These are issues that many employers may face as employees are asked to come back to work but have some change or need that they express to you. After I'm done with that, Bob McTiernan will talk about issues raised when groups of employees raise concerns about safety and health issues. And when Bob is done, I'll pop back on and discuss some very recent and important developments regarding PPP loans before we address some questions at the end, time permitting. So my first subject is a variation on the themes that Jeremy and Kate just touched on. They outlined how to look at situations when an employee is unable to work or telework. And those employees, for all the reasons they talked about, maybe qualify for paid leave under the Families First Act because they can't work at all. But what if the employee can work, but with an asterisk? They ask for some part of their job to change. They express to you they can do their job if you make some change, if you eliminate a duty, if you allow them to adopt a certain schedule, or, and I think this can be common, if they've been working remotely this whole time. You call them back to the office and they say, hey, I've been doing okay. You've been telling me I've been doing great working remotely. I'm afraid of coming in and getting myself sick or my 85-year-old grandmother who lives with me sick. Why can't I continue to work from home? So notice, those aren't no's, no, I can't come in, no, I can't work. They're yes with an asterisk. How is an employer to respond when an employee isn't saying that they can't work at all, but they're asking you to change some part of the job? Well, how the employer responds and what steps the employer has to go through depends on the reason for the ask. This is really important, so I'm going to repeat it. It depends on the underlying reason for their request for a change. If the change the employee is requesting is due to a health condition of the employee, you may have an ADA issue, an Americans with Disabilities Act issue. And if you do, you may have to go through a process before you say no or before you give the answer. This is very tricky. It's always been tricky. ADA has always been difficult in a lot of ways, even before coronavirus. But it's very tricky because it's not particularly intuitive. And if you really think about it, it's tricky because in a lot of ways, it's an exception to life. It's not what most of us are wired for, particularly or especially or including employers. In virtually all areas of life, if you offer someone something and they ask for a change to what you've offered, you can usually say yes or no depending on how you please. You don't typically have to legally go through a process to get a deep understanding about their counteroffer and then figure out whether you have to say yes or no. So, for example, I'm a parent of 2 kids. When they were teenagers, if I had let my daughter use the Camry to go to the store on Friday, but she comes back and says, thanks for letting me go to the store on Friday with the Camry, but instead I would like to use the Lexus for the whole weekend to go on a road trip, I don't typically have a legal obligation to explore her asterisk response. I don't have to go through a process to respond to her request for more or different than I offered. I can say yes or no based on my desire. And similarly, in an employment situation, if you offer, for example, someone a job at $55,000 a year, 2 weeks vacation, and they counter, which they're allowed to do, at $70,000 in 3 weeks, you don't typically have to worry that there's a legal process you have to go through to assess what's essentially a request for a change. So that's why the ADA is a special and complicated place. It is an exception to that general rule, and it requires a bit of rewiring in an employer's brain. So here's how you need to look at this. If the employee raises an issue for a change. So use my example before. You call them back, effective Monday, good news, we're reopening the office now that we're in the yellow state in Pennsylvania, and the employee says, well, I definitely want to work and I can work, but I just like to keep working at home. Here are the issues. If that request is due to a health condition of the employees, health condition, you have an obligation under the ADA to go through a process. You may be able to say no, but you can't say no right away. You have to go through the process to determine whether you have that right. So let's walk through this together. And this, again, is unusual. In employment law, as I said earlier, most of the time, you don't have to go through this process. Accommodation obligations really exist in two places. When there's an ADA disability issue or when there's a religious accommodation issue. In most other situations, an employee's issue doesn't put on an employer an obligation to accommodate. So here's some key principles to an ADA issue. Find out whether the request is due to the employee's health condition. Now, it's okay to ask when someone asks for something different. It's okay to ask what is making them ask. Now, remember, as you're asking, you're just trying to ascertain at this level whether the request is due to the employee's own health condition. Don't go further and ask details about the underlying condition. You don't need to know the name of the diagnosis, whether it's treatment, medication, and so forth. Ask whether the reason for their request is due to their own health condition. And if it is, then it's okay to ask for medical documentation about the capabilities and limitations they have. If there's some part of the job they can't do, some condition they must have. But again, don't ask about specific private medical information. Ask for capabilities, limitations, rather than the underlying medical reason for them. It's certainly okay to ask them what their requested accommodation is, but the ADA doesn't require you to necessarily say yes to that. If there's another accommodation that accomplishes the same thing but is less burdensome to the employer, that's something that you can interact with an employee and understand. So the next concept is focus on whether the condition is a disability. Not all health conditions give someone the right to a reasonable accommodation. A common cold doesn't, it's a minor injury. It has to rise to the level of a definition of disability, which is usually a mental or physical health condition that substantially limits a major life function. Next key principles, and I'll repeat these all just so we have a full set. Next key issue is focus on whether the accommodation will allow the employee to perform the essential job functions. This is really where it comes down to. Every employer has a right to make sure that employees who come to work, whether they have an accommodation or not, can actually perform the job functions that are the essence of the job. Next, focus on how burdensome the accommodation will be. Employers don't have to provide accommodations even if they are accommodations due to a disability if it's unduly burdensome, and usually that's framed in terms of the cost. And again, just to wrap things up, remember that this is a process. It's an interactive process, which means you can't say no right away if the request is due to the condition. So 7 key principles. 1, it's okay to ask what is the basis for the request. Just don't ask about the medical details. Number 2, it's okay to ask for documentation, medical documentation from a healthcare provider about the limitations, capabilities, accommodation needs. Just don't ask about the specific private medical info. Number 3, it's okay to consider the requested accommodation, but it's also okay to consider other ones that will do the job. Number 4, focus on whether the condition rises to the level of disability. Number 5, focus on whether the accommodation will allow the employee to perform the essential job functions of that job. Number 6, focus on how burdensome it will be if you grant the request or a request. And lastly, you can't say no right away. So with that summary, again, none of this is new. The ADA existed long before coronavirus, but you're going to have situations come up, particularly in this transitional phase where people ask for some change. And I want you to walk through these steps that we just talked about to get yourself to the right answer from an ADA standpoint. With that, I'm going to hand it over to Bob McTiernan.
Bob?
We're working out Bob coming online, but while we're waiting to do that, let me go ahead and talk about the PPP
Oh, I'm sorry.
loans, and then
I'm sorry. I apologize. I had a little of a glitch there. Are you okay? Can I proceed?
Yep. Go ahead, Bob.
Yes, thank you. As Albert had mentioned, one of the things that has changed in the context of this unprecedented problem with the coronavirus is it has shifted some of the attention of employers and the public away from dealing with individual employees to dealing with employees as a group. You know, those of us in the employment law field have traditionally worked with an individual employee. A lot of the rights and a lot of the statutes that we're talking about today deal with individual employee rights. But I think you can see from the context of even the news that there is a shift to looking at groups of employees who have common concerns and anxieties, common concerns about safety, and employee policies that affect employers and employees as a group. This is most evident, I think, in some of the increased labor relations activity and union activity that you can see in the media. For example, probably the nation's worst hotspot at a single area of employment was the JBS plant in Michigan, which is an organized plant represented by the United Food and Commercial Workers. The crisis that was created there led to a walkout, a strike, ordinarily would have been considered potentially a wildcat strike, but instead led to a number of accommodations by the employer, including hazardous pay increases of $4 an hour, $600 bonuses related to employees who were willing to come to work, administrative changes such as staggered breaks, eye shields, dividers between employees. These were all negotiated between the employer and the union, including a plan that allowed employees over 60 years old to remain at home during the worst part of the initial crisis with full pay and full benefits. So that is more typically seen in the union environment. But even here in Pennsylvania, some of you may have noted that the United Food and Commercial Workers in Pennsylvania have actually undertaken a publicity campaign, and you might have seen some of those commercials on TV with their president, Wendell Young. Now, we know the union's local in Pennsylvania, Local 1776, primarily for the fact that they represent some 300 state store employees who have not worked during the crisis up until recently for takeout service only. But that union represents 30,000 clerks, frontline workers, approximately 600 of whom have contracted COVID and several of whom have died. So again, they represent a group of employees that we're used to thinking of as clerks, and now we see as frontline and essential workers. The importance of this increased union activity is, as it has in the past, I think it does spill over directly into organized workforces in the non-union sector. And even if you just mention some of the larger non-union employers, such as Whole Foods, Instacart, Target, they have experienced strikes and threats of strikes based on employees who are expressing a safety concern, both in terms of wages and working conditions. There's been a lot of publicity about the fact that Kroger's is dealing with their employees over the issues of continuing hazardous pay and hazardous work conditions bonuses. Amazon's plant here in Poconos is one of the largest hot spots in Pennsylvania, with an outbreak here in Pennsylvania, and it led to various job actions and even the resignation of one of Amazon's vice presidents over the discharge of certain employees. And this is a trend that is becoming more typical. Even before this crisis, the action of employee groups that are not necessarily unionized groups, but engage in group activity. I mean, some of the names are probably familiar to anyone who watches television or reads the paper. Target Workers Unite, Our Walmart,
And these are successor groups of groups like the Fight for 15, Justice for Janitors. They engage in group activity and publicity, even though they are not a recognized bargaining unit representative in the workplace. One of the most heavily publicized incidents recently is Amazon. The Amazon Employees for Climate Justice presented a video presentation nationwide with the writer Naomi Klein and a group of warehouse workers who were reaching out to tech workers and what they call a different silo of employees to try to gain solidarity with them in their actions against Amazon with respect to workplace conditions for the warehouse employees. And they had arranged to sick out on May the 1st. And, you know, these are group actions totally out of the context of traditional labor relations. So you might ask yourself, and a lot of our listeners, I'm sure, are smaller employers in a non-union environment. You might ask yourself, well, really, does this really have a direct impact on our operation in terms of collective action by employees? We're not an Amazon, which hired 175,000 employees to increase its services during this crisis. We're not, a Walmart or an organized environment like the United Food and Commercial Workers. Well, I think it's important for a couple of reasons, because first and foremost, there has been an increased focus, I think, on some of the employees who provide these essential so-called frontline services: grocery clerks, delivery drivers, janitors, hospital workers, a little bit like first responders after 9/11. I think there is going to be an open-mindedness, a sympathy to claims by those employees, not just with the public, but potentially with some of the government agencies that administer laws covering safety. And also there is a new focus on the issue of safety. It does change the context, and we're going to talk about 3 specific statutes a little bit here, but when employees are looking at safe working conditions, it garners not only a legal protection, but also a caution with government agencies and with the public that might not be present where people are just striving for a higher wage or a higher benefits. So I think it does change the context of some of the discussions that you're going to have with your employees. Also, this whole situation is complicated by the lack of clear guidance by government agencies with respect to this really novel situation. And that might sound peculiar considering all the new laws we have, the regulations you've just heard about, but it is, in fact, only since 2008 that OSHA has had a clear regulation requiring employers to provide personal protective equipment with requirements for the analysis of a hazard, with the supply of appropriate personal protective equipment, the training on its use, the replacement of it. That is a relatively recent adoption by OSHA. And currently, OSHA does not have even a regulation, a permanent regulation covering airborne infectious agents. So we have some guidelines from OSHA. We've had the CDC guidelines issued and pulled back and then represented. So we don't have the same level of guidance in any of these areas that we're traditionally used to as employment law lawyers and HR professionals. For example, the recent guidelines from OSHA talk about engineering, critical engineering changes such as air filtering and sneeze guards, administrative requirements like social distancing. But these are not in the context of a fully adopted regulation following public comment. And in the context of this uncertainty and the gravity of the impact of the virus, there are at least 3 federal laws that I think would be worth talking about a little bit today that provide direct worker protection for actions related to safety issues. And these statutes apply to non-union as well as union employees. And they don't require an employer to be as large as Amazon or Walmart to require compliance. And they take precedence over any state employment at will doctrine. The first is one that I suspect a lot of you are familiar with, and that is Section 7 and Section 8. of the National Labor Relations Act. Section 7 protects an employee's right to engage in concerted activity, and I'm sure that's a phrase that many of you have heard. That is the right of an employee or employees to gather together to talk among themselves about working conditions, to present group grievances, to initiate group action with respect to an entirely broad area. It can involve wages and working conditions. So it is not just restricted to safety practices. It can be related to matters wage and benefit matters that relate to safety, such as hazardous duty pay, extra bonuses, discussion of equipment, testing for employees. Employees can take group action, can protest, can publicize under the NLRB rules and decisions and memos these group concerns, even to the extent that, of a walkout or a walk off the job. And I think that's something that probably the people on this call have some familiarity with, but I think would be a surprise to a lot of employers that there are these substantial employee protections. The bad news for employers in this Section 7 area is there's no objective test. An employee doesn't necessarily have to have a valid safety concern or a credible position on bonus pay or a reasonable position. If the employee and employees honestly believe there are unsafe conditions or unhealthy conditions or an unfairness, there's no objective test that applies as long as they are good faith actions by the group. The good news for employers is that it must be genuinely concerted activity. So you don't have a Section 7 problem unless a group of employees is protesting or an individual is the spokesman for a group or is initiating action on behalf of the employees. And a single employee issuing his or her own complaints or making her own protest about his or her particular working conditions does not necessarily have the protections of Section 7 and Section 8 of the National Labor Relations Act. And in fact, one of the effects of recent appointments to the NLRB is the board has been increasingly clarifying and defining what concerted activity is in a fashion that's more favorable, I think, to employers. They're returning to something called the Myers test. I mean, one of the high water marks for employers is a recent case from the NLRB All-State Maintenance, where a group of skycaps refused to unload a van of soccer equipment from a soccer team because of the history of not being tipped. And although they acted together, the employee who spoke for the group stated in terms of the board held that that was not concerted activity because one of the reasons is the employer did not even have control of the tipping of outside third parties. So one advantage of these recent cases and memos is if somebody files a charge with our region here in Pittsburgh, Region 6, I think the NLRB is going to the regional director is going to scrutinize carefully whether not just that there's a good faith claim, but there's genuine concerted activity extended for mutual aid and protection and just not a complaint by an individual. The second statute is much less well known by employers, and that's Section 502 of the Labor Management Relations Act, the Taft-Hartley Act. And it's the so-called savings provision that says, nor shall quitting of labor by an employee in good faith because of an abnormally dangerous condition at the place of employment be deemed a strike. And that provides rights to an individual employee under certain circumstances to actually refuse to perform a job for safety or health reasons. And I think probably everybody who works in HR has had some kind of a brush with an employee who has raised a safety concern or raised a safety issue as an explanation for why they're not following through on an assignment. Now, this statute provides individual protection, this portion of the national labor laws, but it does have the advantage that not only must the employee believe in good faith that conditions are abnormally dangerous, but there has to be a belief that's supported by an ascertainable objective evidence that the condition poses an immediate threat, a harm to the employee's health and safety. And this has to be objective evidence. So in taking it in the context of this current problem is if somebody returns to work, subjective anxiety about a working condition might definitely not qualify. On the other hand, if an employee can show the employer's not following basic hand sanitation protocols or something of that nature, or if somebody's infected, appropriate cleaning protocols, that potentially could be a basis of a protected activity. So the final statute I want to mention is the OSHA provision 11C that prohibits retaliation against an employee for raising a genuine and objectively verifiable safety concern. And again, this goes back to the issue of individual rights. This prohibits retaliation against an employee, but it does tie the obligation of the employer to objective evidence. I mean, the employee must first ask the employer to eliminate the hazard, and the refusal to do the work must be in good faith, and there must be objective evidence such that a reasonable person would agree there is real danger of death or serious injury as a result of the condition. And that would create potentially an individual right to proceed to the government agency, OSHA specifically, within 30 days of the incident to file a complaint. So those three statutes, as we move forward, are ones that we've not seen a great deal of activity concerning safety issues in recent years. But it appears, at least the initial stages of this crisis, as people return to work, that this definitely can be an issue that we have to keep an eye out as employers or employment lawyers or HR specialists. I would give a couple of just recommendations for dealing with these situations as they arise. And I would recommend A, communication, and B, progressive discipline. I think even the regulations or guidelines that have been issued have recommended stress communication between employers and the employees as a group. As you adopt appropriate return to work orders under the yellow and green phase, communicate the steps that you're taking, invite comment, make adaptations of your return to work processes and procedures. That makes communication more important than ever, particularly with these health and safety prohibitions and guidelines outstanding. The other thing is, of course, progressive discipline where possible, to give people warnings, to give them an opportunity to correct behaviors, to give the employer an opportunity to bring the workplace into a sounder, safer situation. Or if an employee does have to be disciplined or fired, to make sure that you have solid evidence, good witnesses, a good explanation. All of these particular enforcement provisions go through government agencies, which is good and bad. The good aspect of it is, of course, employees don't have to hire a lawyer. They don't have to find a lawyer. All they have to do is make a credible claim to the appropriate agency, such as the NLRB. The advantage to the employer is, at least it's been my experience, that the agencies will scrutinize these claims. I recently represented a group of fast food franchise restaurants, and they each had a discharge, and each of the persons discharged was clearly an activist in the fight for 15. There was no, and that is, of course, the drive for the minimum wage of 15 in the fast food industry. They had participated in demonstrations. They had issued and signed public petitions. They had worn logos on the job. But in each case, the local region, Region 6, rejected the complaints, the charges, and did not issue a complaint, because in each case, the employer had a solid basis of progressive discipline and then an objective evidence of non-hearsay evidence of employee misconduct. So again, as we go into this very uncertain area, communication through reasonable rules and adaptation, a clear evidence and progressive discipline will continue even in this very unusual environment, I think, to be our best protection as employers and employment lawyers and HR specialists. So with that being said, I will turn this back to my colleague, Albert Lee, who's going to change the subject a little bit to the areas of compliance with the loan requirements under the federal law. Albert?
Thanks, Bob. Thanks for that discussion. Lastly, I want to touch on a few things relating to the PPP loans. I won't get too deep in the weeds given our time constraints and also because this may not be relevant to many on the call. For those of you who do have PPP loans and PPP concerns, I'll highlight some of the important developments. There's some big developments just in the last week. And for more information and detail that we can't cover today, if you're interested, please go to an article I just wrote with some colleagues. It's posted on our website, www.tuckerlaw.com. Look for it. It's dated May 18th, 2020, this Monday. So what's happened in the last week? Well, we've had basically two things. Since last Wednesday, we've had the SBA issue 2 FAQs, 2 frequently asked questions. Their numbers 46 and 47 on a long train of FAQs the SBA has issued since the PPP loan program was established. And we also have coming out late Friday, so just last Friday, a application form. It's an 11-page form with a lot of directions and instructions for filling it out that deals specifically with things that a lot of borrowers have wondered about. How do you spend the loan money? How do you maximize your forgiveness? How do you calculate any reductions for forgiveness? And how do you document what you've done with the loan? So again, these are the 4 questions that have been looming. Number 1, with all the negative publicity that your Ruth's Chris's and LA Lakers have gotten, can my business justify having applied for and gotten and kept the PPP loan? Number 1. Number 2, the CARES Act states certain requirements about how we must use the loan proceeds. Quote, costs incurred and payments made was a language in the act. But what does that really mean? The third common question was what circumstances can affect my business's ability to have some or all the loans forgiven? After all, that's the big crowning difference between this loan and most loans is you can potentially have it turn into a grant if you use the money right and you follow other procedures. And then lastly, what documentation to keep. So the 2 FAQs speak to question 1. In a nutshell, those FAQs give very, very good news to borrowers who borrowed less than $2 million. And this has to do with the certification that you made at the time you apply for the loan that you had a necessity and a need due to the uncertainty of COVID-19 crisis to require borrowing the money. In the intervening weeks, since most borrowers fill out that application, there's been a lot of bad news, bad press, proclamations about real scrutiny to make sure that companies really needed the money at the time they certified the need. Well, last Wednesday in these 2 FAQs, a lot of that uncertainty was eliminated for smaller borrowers, what we would say smaller borrowers who borrowed less than $2 million. Those FAQs said if you borrowed less than $2 million, it's assumed that you made that certification of need in good faith. So there's a collective sigh of relief. The estimates are that 99% of borrowers borrowed less than $2 million. So most PPP borrowers no longer have to worry about that. Now that's not to say it's a get out of jail free card for everything else. You made a lot of other certifications when you borrowed the loan, and you have a lot of other obligations in terms of spending the money and so forth. Those still remain. But in terms of the central issue about whether you have the requisite need, you're deemed to have made it in good faith. So questions 2 through 4 are where you go next if you decide to keep the money. This recent application talks a lot about how you can spend the money. There was some uncertainty about timing. If you get the money on the 8th of the month, does that mean you can only pay for the part of the payroll from the 8th to say the 15th if you have a mid-month payroll? This application, this 11-page form, answers that, and it basically gives a very favorable interpretation. So it's all payroll costs and non-payroll costs, costs incurred and costs paid. So you kind of get both ends of it. So if by the time you get the money and you have your 8 weeks to spend it, If you pay a payroll or non-payroll cost, as long as it's a qualifying cost during that period, it's covered. And if you incur a cost, for example, payroll, if you incur a payroll cost, but your payroll that doesn't happen until shortly after the 8 weeks, that can count too. All the details are in there. Again, I'm not going to go into all the chapter and verse. If you go to our website, my article dated May 18th has actual links to both the FAQs that I've mentioned and the application, and you can find them there. I do want to highlight there's a lot of clarity about forgiveness, which of course is a big issue. One of the biggest things about forgiveness is what's been called safe harbors. So even if you have laid people off or cut people's wages, you won't have your forgiveness affected if you qualify for a headcount or a wage safe harbor. If you bring people back, for example, is a common way to put it. If you bring everyone back by June 30th, this application talks in detail about how you have to do that, how that's looked at, what the before and after periods are. So there's a lot of detail I refer you to. And then lastly, page 10 of that 11-page packet goes into a lot of detail about information you have to keep in 2 categories. Information you have to keep and submit with your forgiveness application and the forms that are in that 11-page packet, but also information you don't have to submit, but you should keep in case of an audit or some follow-up questions arise. So with that, we'll conclude our program. We have a little bit of time that we saved for some questions. I'll go through some of the questions that have been submitted. And again, thank you for joining us today. So the first question I will tee up for Kate. This has to do with the FFCRA. And the question is an employee eligible to not take the Families First Coronavirus Response Act leaves and remain on layoff because they believe they will make more money? And if so, what should be documented? Kate?
Thanks, Albert. So if you first have offered an employee to return to work and they are indicating that they don't want to return to work because they have some need or leave that would qualify under the FFCRA, there's new guidance out from the Pennsylvania Department of Labor and the Pennsylvania Unemployment Compensation Bureau that indicates you, one, can have a conversation with your employee to determine what would be best for you in the employee situation, and that's under their Q&As, and you can read that. But if you have work for the employee and you want them to return to work, it's not at the employee's discretion to reject an offer. And the Pennsylvania Unemployment Bureau, in fact, says that if an employee refuses to return to work because they can make more money receiving UC benefits, you should complete what's called the UC Form 1921W. And so if an employee that you ask refuses to return to work, they must return to work unless they have good cause for refusing the offer. Now, good cause could, of course, is fact specific. The employee could say, like Albert discussed, perhaps their concerns regarding the ability for them to safely perform their job duties with or without reasonable accommodations, and that's a fact-specific inquiry that the Unemployment Compensation Bureau said that they would dig into if there's a refusal of work. Those are fact-specific circumstances, but in general, no, an employee can't simply refuse to return your offer of work simply because they'll make more money on unemployment as they would on FFCRA leave. And of course, as Albert discussed also related to the PPP loan, if an employee does refuse a good faith offer of work, you may be able to claim some safe harbor provisions if you're an employer who has a PPP loan when you're determining those numbers for payroll and FTEs that you've rehired. I'll turn it back over to Albert to address our next question.
Thanks, Kate. And the next question is somewhat related, something Kate touched on in the answer to the last question, and that is, do we have to report to unemployment if an employee chooses to not come back to work? And the answer is that the Unemployment Bureau in Pennsylvania has asked employers to, in the interest of helping the integrity of the unemployment system, to report if they have made an offer to work that's been refused. And to do so, you use the form that Kate mentioned before, which is Form 1921W. Another question is, do we have an obligation to bring back an employee that was laid off, but we've objectively made decision that we've better options? This is a question that is similar to the questions that people had long before coronavirus. If someone was laid off for other reasons long before we had COVID-19, the idea of not bringing someone back depends on a couple things. First of all, if someone has a protected right to a job, Jeremy mentioned job protected leaves like FMLA and so forth. If someone has some legal protection to coming back, then of course you have to explore that. That legal protection could come through statutes, for example, like the FMLA if they qualify, Families First Act if they qualify, but also under certain contracts. If in a union world, the world that Bob McTiernan talked about, if in a union world you have a union contract that talks about layoffs and recalls and in what order you have to pay to recall people, obviously contracts that are binding you have to explore. But short of those things, employers have some discretion in terms of who they bring back. The key thing, of course, is not bringing someone back is a tangible job action. So you have to make sure that you can survive scrutiny to all the typical challenges an employee can bring, usually via theories like discrimination, when they have had a tangible job action not go their way. So I think we have time for maybe one more question or so. Is there a template or a special way to do a written offer of same job, same hours that we use for laid off employees now that the economy is opening up? And my panelists have any feedback or input on that question? Is there a template or a certain way that we should offer employees back or who've been laid off? I'll go ahead and give my 2 cents, and people can chime in if they want. In the employment world, typically, there's no legal obligation to make job offers in writing. Kate mentioned that the PPP adds a twist to that. If for PPP reasons you want to show that you made someone an offer so that when they refuse and you don't get a head count, you don't get penalized for that for PPP reasons, these recent developments and guidance from the SBA say that that offer has to be in writing. Also, in terms of unemployment, there are certainly benefits if you want to escape some unemployment issues to doing it in writing. And of course, setting even those issues aside, there's typically a wisdom for making written offers, even if they're not legally required to be made in writing, because that eliminates disputes over what you're offering. I've told clients for a while now that when you call people back, be very specific with them, and in writing is a very clear way to be specific with folks. Be specific, particularly if some aspect of their job is different than it was pre-COVID. If the hours are different, if you're going to have them report to a different place, if their duties are going to change, that's certainly a good way to memorialize that. Well, we've reached our time. It is just about 1:30. On behalf of the entire firm, my fellow speakers, I want to thank all of you for joining us today. Again, I direct you to our website if you have any questions about any of the myriad of issues we've written about, and we wish you all the health and safety out there. Thank you again.